This audio case is brought to you by Laudio. Lucy v. Zehmer, Supreme Court of Virginia, November 22, 1954. Procedural posture. Plaintiffs appealed decision of the Circuit Court of Dinwiddie County, Virginia, holding plaintiffs were not entitled to specific performance on a contract for the sale of the defendant's real estate to plaintiffs. Defendant husband wrote and signed a contract to sell his farm to plaintiffs and persuaded defendant wife to sign by telling her the contract was a joke on plaintiffs. When plaintiffs attempted to finalize sale, defendants attempted to deny contract on the grounds that defendant husband was drunk when making the contract and the contract was a joke on plaintiffs. Plaintiffs sued for specific performance. The trial court found for defendants. On appeal, the court reversed and remanded. Defendants' true intent in agreeing to sell their farm was not determinative, so long as their words and actions warranted a reasonable person's belief that a contract was intended. Plaintiffs reasonably believed the sale contract was a serious business transaction. The evidence suggested defendant husband was not too drunk to know what he was doing. Outcome. The court reversed and remanded because the contract was a binding contract of sale between the parties, despite defendants' claim that they had not intended to sell their farm and that the sale contract had been intended as a joke. Opinion. J. Buchanan delivered the opinion of the court. This suit was instituted by W. O. Lucy and J. C. Lucy, complainants, against A. H. Zehmer and Ida S. Zehmer, his wife, defendants, to have specific performance of a contract by which it was alleged the Zehmers had sold to W. O. Lucy a tract of land owned by A. H. Zehmer in Dinwiddie County containing 471.6 acres, more or less, known as the Ferguson Farm, for $50,000. J. C. Lucy, the other complainant, is a brother of W. O. Lucy, to whom W. O. Lucy transferred a half interest in his alleged purchase. The instrument sought to be enforced was written by A. H. Zehmer on December 20th, 1952, in these words, quote, "We hereby agree to sell to W. O. Lucy the Ferguson Farm complete for $50,000, title satisfactory to buyer," end quote, and signed by the defendants A. H. Zehmer and Ida S. Zehmer. The answer of A. H. Zehmer admitted that at the time mentioned, W. O. Lucy offered him $50,000 cash for the farm, but that he, Zehmer, considered that the offer was made in jest, that so thinking, and both he and Lucy having had several drinks, he wrote out, quote, the memorandum, end quote, quoted above, and induced his wife to sign it, that he did not deliver the memorandum to Lucy, but that Lucy picked it up, read it, put it in his pocket, and attempted to offer Zehmer $5 to bind the bargain, which Zehmer refused to accept, and realizing for the first time that Lucy was serious, Zehmer assured him that he had no intention of selling the farm and that the whole matter was a joke. Lucy left the premises, insisting that he had purchased the farm. Depositions were taken, and the decree appealed from was entered, holding that the complainants had failed to establish their right to specific performance and dismissing their bill. The assignment of error is to this action of the court. W. O. Lucy, a lumberman and farmer, thus testified in substance. He had known Zehmer for 15 or 20 years and had been familiar with the Ferguson Farm for 10 years. 7 or 8 years ago, he had offered Zehmer $20,000 for the farm, which Zehmer had accepted, but the agreement was verbal and Zehmer backed out. On the night of December 20th, 1952, around 8 o'clock, he took an employee to McKinney, where Zehmer lived, and operated a restaurant, filing station, and motor court. While there, he decided to see Zehmer and again tried to buy the Ferguson Farm. He entered the restaurant and talked to Mrs. Zehmer until Zehmer came in. He asked Zehmer if he had sold the Ferguson Farm. Zehmer replied that he had not. Lucy said, quote, "I bet you wouldn't take $50,000 for the place," end quote. Zehmer replied, quote, "Yes, I would too. You wouldn't give 50, end quote. Lucy said he would and told Zehmer to write up an agreement to that effect. Zehmer took a restaurant check and wrote on the back of it, quote, I do hereby agree to sell to W.O. Lucy the Ferguson farm for $50,000 complete, end quote. Lucy told him he had better change it to, quote, we, end quote, because Mrs. Zehmer would have to sign it too. Zehmer then tore up what he had written, wrote the agreement quoted above, and asked Mrs. Zehmer, who was at the other end of the counter 10 or 12 feet away, to sign it. Mrs. Zehmer said she would for $50,000 and signed it. Zehmer brought it back and gave it to Lucy, who offered him $5, which Zehmer refused, saying, quote, you don't need to give me any money. You got the agreement there signed by both of us, end quote. The discussion leading to the signing of the agreement, said Lucy, lasted 30 or 40 minutes, during which Zehmer seemed to doubt that Lucy could raise $50,000. Lucy suggested the provision for having the title examined, and Zehmer made the suggestion that he would sell it, quote, complete everything there, end quote, and stated that all he had on the farm was 3 heifers. Lucy took a partly filled bottle of whiskey into the restaurant with him for the purpose of giving Zehmer a drink if he wanted it. Zehmer did, and he and Lucy had 1 or 2 drinks together. Lucy said that while he felt the drinks he took, he was not intoxicated, and from the way Zehmer handled the transaction, he did not think he was either. December 20th was on Saturday. Next day, Lucy telephoned to J.C. Lucy and arranged with the latter to take a half interest in the purchase and pay half of the consideration. On Monday, he engaged an attorney to examine the title. The attorney reported favorably on December 31st, and on January 2nd, Lucy wrote Zehmer stating that the title was satisfactory, that he was ready to pay the purchase price in cash, and asking when Zehmer would be ready to close the deal. Zehmer replied by letter, mailed on January 13th, asserting that he had never agreed or intended to sell. Mr. and Mrs. Zehmer were called by the complainants as adverse witnesses. Zehmer testified in substance as follows. He bought this farm more than 10 years ago for $11,000. He had had 25 offers, more or less, to buy it, including several from Lucy, who had never offered any specific sum of money. He had given them all the same answer, that he was not interested in selling. On this Saturday night before Christmas, it looked like everybody and his brother came by there to have a drink. He took a good many drinks during the afternoon and had a pint of his own. When he entered the restaurant around 8:30, Lucy was there, and he could see that he was pretty high. He said to Lucy, quote, boy, you got some good liquor, drinking, ain't you? End quote. Lucy then offered him a drink. Quote, I was already high as a Georgia pine and didn't have any more better sense than to pour another great big slug out and gulp it down, and he took one too, end quote. After they had talked a while, Lucy asked whether he still had the Ferguson farm. He replied that he had not sold it, and Lucy said, quote, I bet you wouldn't take $50,000 for it, end quote. Zehmer asked him if he would give $50,000, and Lucy said yes. Zehmer replied, quote, you haven't got $50,000 in cash, end quote. Lucy said he did, and Zehmer replied that he did not believe it. They argued, quote, pro and con for a long time, end quote, mainly about, quote, whether he had $50,000 in cash that he could put up right then and buy that farm, end quote. Finally, said Zehmer, Lucy told him if he didn't believe he had $50,000, quote, you sign that piece of paper here and say you will take $50,000 for the farm, end quote. He, Zehmer, quote, just grabbed the back of a guest check there and wrote on the back of it. At that point in his testimony, Zehmer asked to see what he had written to see, quote, see if I recognize my own handwriting, end quote. He examined the paper and exclaimed, quote, great balls of fire, I got Ferguson for Ferguson. I have got satisfactory spelled wrong. I don't recognize that writing if I could see it. Wouldn't know it was mine, end quote. After Zehmer had, as he described it, quote, scribbled this thing off, end quote, Lucy said, quote, get your wife to sign it, end quote. Zehmer walked over to where she was, and she at first refused to sign, but did so after he told her that he was, quote, was just needling him, Lucy, and didn't mean a thing in the world, that I was not selling the farm, end quote. Zehmer then, quote, took it back over there, and I was still looking at the darn thing. I had the drink right there by my hand, and I reached over to get a drink, and he said, let me see it. He reached and picked it up, and when I looked back again, he had it in his pocket, and he dropped a $5 bill over there, and he said, here is $5, payment on it. I said, hell no, that is beer and liquor talking. I am not going to sell you the farm. I have told you too many times before, end quote. Mrs. Zehmer testified that when Lucy came into the restaurant, he looked as if he had had a drink. When Zehmer came in, he took a drink out of a bottle that Lucy handed him. She went back to help the waitress who was getting things ready for the next day. Lucy and Zehmer were talking, but she did not pay too much attention to what they were saying. She heard Lucy ask Zehmer if he had sold the Ferguson farm, and Zehmer replied that he had not and did not want to sell it. Lucy said, quote, I bet you wouldn't take $50,000 cash for that farm, and Zehmer replied, you haven't got $50,000 cash, end quote. Lucy said, quote, I can get it, end quote. Zehmer said he might form a company and get it, but, quote, you haven't got $50,000 cash to pay me tonight, end quote. Lucy asked him if he would put it in writing that he would sell his farm. Zehmer then wrote on the back of a pad, quote, I agreed to sell the Ferguson place to W.O. Lucy for $50,000 cash. Lucy said, quote, all right, get your wife to sign it, end quote. Zehmer came back to where she was standing and said, quote, you want to put your name to this thing, end quote. She said, quote, no, end quote. But he said in an undertone, quote, it is nothing but a joke, end quote, and she signed it. She said that only one paper was written and it said, quote, I hereby agree to sell, end quote, but the I had been changed to we. However, she said she read what she signed and was then asked, quote, when you read, we hereby agree to sell to W.O. Lucy, what did you interpret that to mean, that particular phrase, end quote. She said she thought it was a cash sale that night, but she also said that when she read that part about the, quote, title satisfactory to buyer, end quote, she understood that if the title was good, Lucy would pay $50,000. But if the title was bad, he would have a right to reject it, and that was her understanding at the time she signed her name. On examination by her own counsel, she said that her husband laid this piece of paper down after it was signed, that Lucy said to let him see it, took it, folded it, and put it in his wallet, then said to Zehmer, quote, let me give you $5, end quote. But Zehmer said, quote, no, this is liquor talking. I don't want to sell the farm. I have told you that I want my son to have it. This is all a joke, end quote. Lucy then said at least twice, quote, Zehmer, you have sold your farm, end quote, wheeled around and started for the door. He paused at the door and said, quote, I will bring you $50,000 tomorrow. No, tomorrow is Sunday. I will bring it to you Monday, end quote. She said you could tell definitely that he was drinking, and she said to her husband, quote, you should have taken him home, end quote. But he said, quote, well, I am just about as bad off as he, end quote. The waitress referred to by Mrs. Zehmer testified that when Lucy first came in, he was mouthy. When Zehmer came in, they were laughing and joking, and she thought they took a drink or two. She was sweeping and cleaning up for next day. She said she heard Lucy tell Zehmer, quote, I will give you so much for the farm, end quote. And Zehmer said, quote, you haven't got that much, end quote. Lucy answered, quote, oh, yes, I will give you that much, end quote. Then, quote, they jotted down something on paper, and Mr. Lucy reached over and took it, said, let me see it, end quote. He looked at it, put it in his pocket, and in about a minute he left. She was asked whether she saw Lucy offer Zehmer any money and replied, quote, he had $5 laying up there. They didn't take it, end quote. She said Zehmer told Lucy he didn't want his money because, quote, he didn't have enough money to pay for his property and wasn't going to sell his farm, end quote. Both of them appeared to be drinking right much, she said. She repeated on cross-examination that she was busy and paying no attention to what was going on. She was some distance away and did not see either of them sign the paper. She was asked whether she saw Zehmer put the agreement down on the table in front of Lucy, and her answer was this, quote, time he got through writing whatever it was on the paper, Mr. Lucy reached over and said, let's see it. He took it and put it in his pocket before showing it to Mrs. Zehmer. Her version was that Lucy kept raising his offer until it got to $50,000. The defendants insist that the evidence was ample to support their contention that the writing sought to be enforced was prepared as a bluff or dare to force Lucy to admit that he did not have $50,000, that the whole matter was a joke, that the writing was not delivered to Lucy, and no binding contract was ever made between the parties. It is an unusual, if not bizarre, defense. When made to the writing admittedly prepared by one of the defendants and signed by both, clear evidence is required to sustain it. In his testimony, Zehmer claimed that he was, quote, was high as a Georgia pine, end quote, and that the transaction, quote, was just a bunch of two doggone drunks bluffing to see who could talk the biggest and say the most, end quote. That claim is inconsistent with his attempt to testify in great detail as to what was said and what was done. It is contradicted by other evidence as to the condition of both parties, and rendered of no weight by the testimony of his wife that when Lucy left the restaurant, she suggested that Zehmer drive him home. The record is convincing that Zehmer was not intoxicated to the extent of being unable to comprehend the nature and consequences of the instrument he executed, and hence, that instrument is not to be invalidated on that ground. 17 CJS Contracts, Section 133B, page 483, Taliaferro versus Emery, 124, Virginia, 674-98, Southeast 627. It was in fact conceded by defendant's counsel in oral argument that under the evidence, Zehmer was not too drunk to make a valid contract. The evidence is convincing also that Zehmer wrote two agreements, the first one beginning, quote, I hereby agree to sell, end quote. Zehmer first said he could not remember about that. Then that, quote, I don't think I wrote but one out, end quote. Mrs. Zehmer said that what he wrote was, quote, I hereby agree, end quote, but that the I was changed to we after that night. The agreement that was written and signed is in the record and indicates no such change. Neither are the mistakes in spelling that Zehmer sought to point out readily apparent. The appearance of the contract, the fact that it was under discussion for 40 minutes or more before it was signed, Lucy's objection to the first draft because it was written in the singular, and he wanted Mrs. Zehmer to sign it also, the rewriting to meet that objection and the signing by Mrs. Zehmer, the discussion of what was to be included in the sale, the provision for the examination of the title, the completeness of the instrument that was executed, the taking possession of it by Lucy with no request or suggestion by either of the defendants that he give it back, are facts which furnish persuasive evidence that the execution of the contract was a serious business transaction rather than a casual, jesting matter as defendants now contend. On Sunday, the day after the instrument was signed on Saturday night, there was a social gathering in a home in the town of McKinney, at which there were general comments that the sale had been made. Mrs. Zehmer testified that on that occasion, as she passed by a group of people, including Lucy, who were talking about the transaction, $50,000 was mentioned, whereupon she stepped up and said, quote, well, with the high-priced whiskey you were drinking last night, you should have paid more, end quote. Lucy testified that at that time Zehmer told him that he did not want to, quote, stick him, end quote, or hold him to the agreement because he, Lucy, was too tight and didn't know what he was doing. To which Lucy replied that he was not too tight, that he had been stuck before and he was going through with it. Zehmer's version was that he said to Lucy, quote, I am not trying to claim it wasn't a deal on account of the fact the price was too low. If I had wanted to sell $50,000 would be a good price. In fact, I think you would get stuck at $50,000, end quote. A disinterested witness testified that what Zehmer said to Lucy was that, quote, he was going to let him up off the deal because he thought he was too tight, didn't know what he was doing. Lucy said something to the effect that, quote, I have been stuck before and I will go through with it, end quote. If it to be assumed, contrary to what we think the evidence shows, that Zehmer was jesting about selling his farm to Lucy, and that the transaction was intended by him to be a joke, nevertheless, the evidence shows that Lucy did not so understand it, but considered it to be a serious business transaction, and the contract to be binding on the Zehmers as well as on himself. The very next day, he arranged with his brother to put up half the money and take a half interest in the land. The day after that, he employed an attorney to examine the title. The next night, Tuesday, he was back at Zehmer's place, and there Zehmer told him for the first time, Lucy said, that he wasn't going to sell, and he told Zehmer, quote, you know you sold that place fair and square, end quote. After receiving the report from his attorney that the title was good, he wrote to Zehmer that he was ready to close the deal. Not only did Lucy actually believe, but the evidence shows he was warranted in believing that the contract represented a serious business transaction and a good faith sale and purchase of the farm. In the field of contracts, as generally elsewhere, quote, we must look to the outward expression of a person as manifesting his intention, rather than to his secret and unexpressed intention. The law imputes to a person an intention corresponding to the reasonable meaning of his words and actions. First National Bank versus Roanoke Oil Company, 169 Virginia 99, 114192 Southeast 764 770. At no time prior to the execution of the contract had Zehmer indicated to Lucy by word or act that he was not in earnest about selling the farm. They had argued about it and discussed its terms, as Zehmer admitted, for a long time. Lucy testified that if there was any jesting, it was about paying $50,000 that night. The contract and the evidence show that he was not expected to pay the money that night. Zehmer said that after the writing was signed, he laid it down on the counter in front of Lucy. Lucy said Zehmer handed it to him. In any event, there had been what appeared to be a good faith offer and a good faith acceptance, followed by the execution and apparent delivery of a written contract. Both said that Lucy put the writing in his pocket and then offered Zehmer $5 to seal the bargain. Not until then, even under the defendant's evidence, was anything said or done to indicate the matter was a joke. Both of the Zehmers testified that when Zehmer asked his wife to sign, he whispered that it was a joke so Lucy wouldn't hear and that it was not intended so that he should hear. The mental assent of the parties is not requisite for the formation of a contract. If the words or other acts of one of the parties have but one reasonable meaning, his undisclosed intention is immaterial except when an unreasonable meaning which he attaches to his manifestations is known to the other party. Reinstatement of the Law of Contracts, Volume 1, Section 71, page 74. The law, therefore, judges of an agreement between two persons exclusively from those expressions of their intentions which are communicated between them. Clark on Contracts, 4th edition, Section 3, page 4. An agreement or mutual assent is of course essential to a valid contract, but the law imputes to a person an intention corresponding to the reasonable meaning of his words and acts. If his words and acts, judged by a reasonable standard, manifest an intention to agree, it is immaterial what may be the real but unexpressed state of his mind. 17 CJS Contract, Section 32, page 361. So a person cannot set up that he was merely jesting when his conduct and words would warrant a reasonable person in believing that he intended a real agreement. 17 CJS Contracts, Section 47, page 390. Clark on Contracts, 4th edition, Section 27, at page 54. Whether the writing signed by the defendants and now sought to be enforced by the complainants was the result of a serious offer by Lucy and a serious acceptance by the defendants, or was a serious offer by Lucy and acceptance in secret jest by the defendants, in either event, it constituted a binding contract of sale between the parties. Defendants contend further, however, that even though a contract was made, equity should decline to enforce it under the circumstances. These circumstances have been set forth in detail above. They disclose some drinking by the two parties, but not to an extent that they were unable to fully understand what they were doing. There was no fraud, no misrepresentation, no sharp practice or dealing between unequal parties. The farm had been bought for $11,000, and it was assessed for taxation at $6,300. The purchase price was $50,000. Zehmer admitted that it was a good price. There is in fact present in this case none of the grounds usually urged against specific performance. Specific performance, it is true, is not a matter of absolute or arbitrary right, but is addressed to the reasonable and sound discretion of the court. First National Bank versus Roanoke Oil Company, Supra, 169, Virginia, at page 116, 192. But it is likewise true that the discretion which may be exercised is not an arbitrary or capricious one, but one which is controlled by the established doctrines and settled principles of equity. And generally, where a contract is in its nature and its circumstances unobjectionable, it is as much a matter of course for courts of equity to decree a specific performance of it as it is for a court of law to give damages for a breach of it. Bond versus Crawford, 193, Virginia, 437, 444, 69, SE, 2nd Division, 470, 475. The complainants are entitled to have specific performance of the contract sued on. The decree appealed from is therefore reversed, and the cause is remanded for the entry of a proper decree requiring the defendants to perform the contract in accordance with the prayer of the bill. Reversed and remanded.